Professor Smith is an associate professor in broadcast and electronic communication arts at San Francisco State University. She teaches media law, media management and economics, and media ethics and mobile media. Professor Smith is here today to present a paper that she's working on, hashtag Black Lives Matter, a hashtag, a rallying cry, a social movement, a global network, but not a trademark. And so with that, we will turn the time over to her. And thank you so much, Professor Smith.
Thank you. It's really a privilege for me to be here. This is a very esteemed group, very, brilliant minds have gathered here, and then there's me, but that's okay. And I'm really excited to share my research. I do also want to thank those Peter and Michaela, who made this, made sure this was going on and made it possible. And I'm very appreciative of all of your attendance. One of the things I've really struggled with as I've done this research, worked on this paper, is to find my audience. I am accustomed for the past 23 years, I've been teaching, as Peter said, law to undergraduates. And their needs are very different than what one would expect from a law journal article. And I'm welcoming your participation. You don't need to wait until the end with questions, answers, but I will tell you what I've found, what I've discovered. This topic first came to my mind when I read in 2015 about the Trademark Office refusing applications for people who were trying to register Black Lives Matter. And it prompted me to say, well, why? What's behind it? What's going on? I've always enjoyed copyright and trademark law, and also always been a fan of the catchphrase, of the short phrase. In fact, I'm still looking for my own, but someday I'll find it. But this is really the story of the convergence of, social change, social protest, brought on by a catchphrase, a short phrase with a hashtag, which is like slogans on steroids, right? And t-shirts, it's behind a lot of it. And of course, trademark law. And so I said, well, let's get to the root of all of this. Let's get to the beginnings of it all, the basics. And so to find the root of the word slogan, one would have to go back to an even earlier version of Scotland than this is, and learn that, slogan was the equivalent of a battle cry, a rallying cry. And then, as I mentioned, when you add the hashtag to it, it is on steroids, any catchphrase, and you mix it in with social media. And then you have tragic events such as the death of Trayvon Martin. And you have a surge. This is the era when Black Lives Matter as a phrase, as a hashtag came into being, and it was studied. It was pivotal. And then, of course, the tragic death in May of 2020, the murder of George Floyd, and then everything just exploded. And yes, all my images are public domain. This is actually from the Mauer Park in Berlin. It's not just the US, this is global, these concerns. And people have studied, the usage of Black Lives Matter and seen the surges and noted the surges. There is no doubt that at this point in time, there will be few hashtags, few slogans, few catchphrases that will have the impact that Black Lives Matter. Black Lives Matter has had. Okay, it's iconic, it's changed society, it's everywhere. Okay, what about trademark law? Does it match up well with an iconic phrase that seems ubiquitous, that seems to belong to everybody? Well, trademark law wants to protect things that are distinctive and indicate a source. So immediately, the first thought, one can see the struggle between the tension existing between a ubiquitous phrase and trademark law. They seem to be at opposite ends. Despite that, between 2015 and 2016, applications for trademarks surged 64%. It's a dramatic increase. It seems everyone wants to have a trademark. And also in July of 2017, the Trademark Office worked to amend the Trademark Manual of Examining Procedure by issuing a statement. It was at the time called on merely informational matter, but it's now incorporated into the Trademark Manual of Examining Procedure as widely used messages. And it added to our understanding of, three categories of widely used messages. And that's any message that's an information about goods, any phrase that's commonly used, and messages that quote religious text. So this is not ground-shaking, groundbreaking additions, but clarification and an augmentation of the understanding of things that should not be subject to trademark protection. And again, why? What's going on? What are people doing? And clearly, there is a phrase that explains it. Show me the money. Show me the money was actually trademarked by someone who saw the movie. He saw the movie, Jerry Maguire, raced to the Trademark Office, express mail, and filed an application for the phrase, and literally had TriStar Studios paying him an enormous sum of money because he held the rights to that phrase and they wanted it. And this is the proverbial gold rush now to the Trademark Office. When I looked at the applications, there's been 89 applications for the phrase Black Lives Matter. 51, more than half, were for some form of clothing, what one trademark scholar has referred to as billboard goods. Part of the reason that these applications show up in the Trademark Office is that copyright law will not protect the short phrase. And so if you want any sort of exclusivity, you need to have a trademark protection and claim it's your brand. But t-shirts are not the only way that phrases can make money. The organization, the Black Lives Network Foundation, the global network that was founded by the originators of the phrase Black Lives Matter, Garza, Cullors, and Tometi, they finally released their financials in 2020, and they had taken in $90 million from fundraising, with the average amount being donated to them $30. So you can see just the widespread support for their work, prompted by the hashtag. They spent $30 million and have $60 million to go into 2021, according to their records. One study was done of how much has the phrase generated by corporate giving, to various relevant organizations that were doing social justice work, and the amount was $1.678 billion. And in one account, which I was unable to verify, then a prominent activist went out and had the corporations match that amount. Whether all that money has actually been received or spent is not known, but it's there. So the question becomes, inherently, trademark law is just not going to protect a phrase like Black Lives Matter. It's not its nature. It's not designed to do that. In fact, in looking at the 89 applications, only 72 actually use the exact phrase Black Lives Matter. But in looking at many of the applications, the first thought that I had was, quite frankly, this would not make for a good trademark. It's quite clear they were just seeking to protect their design. While a design is protectable if they disclaim the words Black Lives Matter. This is not the only time that people have sought to, capture a phrase. Three-peat was registered not by Byron Scott, the Lakers player, it was registered by the coach, Pat Riley. There seemed to be a fight over the phrase, let's roll. And so scholars have written about this and have said that what really needs to happen is, you need to have secondary meaning attached before anything can be registered. Currently, you can, if it's felt that your application, that what you're seeking to protect is merely descriptive, you can register it on a supplemental. You can say, I'm going to use this. But one proposal is that, you must have secondary meaning that the phrase is a source indicator. And also, you would require that only those who held publicity rights to the phrase could register it. There have been other studies done, other considerations of tag marks, hashtags that become trademarks. And the thought on that is also that they must acquire secondary meaning, that it's just considered, no matter how distinctive it might look, just consider a hashtag until it is proven that it has secondary meaning. Other scholars looked at the same filings for Black Lives Matter from a critical race theory, intellectual property perspective. I see there is one question. So publicity rights would attach to, let's say, the example was after the Washington Nationals won the World Series, one of the reporters asked the Rookie of the Year, Bryce Harper, who was then 19 years old, if he was going to go out and drink a beer. He was in Canada at the time, legal age to drink there. But in many states, 19 is not legal age to drink. So I guess to the journalist, it seemed like a fun question. I mean, that is quite young for a Rookie of the Year. And Bryce Harper, who is a member of the Church of Jesus Christ of Latter-day Saints and does not drink alcohol, responded to the journalist's question by saying, "That's a clown question, bro." And that went viral. It was just an offhand remark, but as so many phrases do, they go viral. No one's expecting it. Nobody knew in Jerry Maguire what phrase would catch on, although several did. So Bryce Harper actually the next day filed for trademark rights, trademark protection of his phrase. So the idea is because he said that, had the right of publicity rights to that phrase. It was connected to him. He was the one who said it. The fight over let's roll, the the family of Todd Beamer. So Let's Roll was the last thing that Todd Beamer was said to have said when he and fellow passengers on United Airlines Flight 91 disrupted the hijackers' plans to crash their passenger airline into either the Capitol, US Capitol, or the White House. And they took down the hijackers, and everyone on the flight crashed into a field in Pennsylvania, 10 years ago. So clearly Todd Beamer, who was heard by a telephone operator, an in-flight phone operator, to have said that before he and his fellow passengers jumped up for the heroic action, his family should have rights to that, the publicity rights. Instead, the person who filed it was, I think, a New Yorker by the name of Imam Abdallah. But there was procedures in the Trademark Office. There was disputation, opposition, and the mark to Let's Roll was finally registered with the Beamer Foundation. So it just, if you say something that goes viral, you have a headache, you don't go out and register what you said right away. You don't even know you're viral, like the attorney in Texas who appeared in court as a cat. He didn't even know he was famous for not being a cat until someone told him. I guess he has rights to that phrase, I'm not a cat, Your Honor. Well, that would be a good one. So that is the problem with Let's Roll. The Let's Roll trademark has been abandoned, so no one's claiming that. And then you also get, it's First Amendment questions. I mean, what is it that you really, if you do get a catchphrase, a common phrase, what is it that you really do own? I think the days of show me the money are over, because there's other defenses you could raise should you get through the process of actually becoming a trademark, which is not, it takes probably a year for that process. People can extend, their need to demonstrate use. They can file an intent to use application, and they can have up to 3 years by filing timely extensions. They can have up to 3 years to prove that they are actually using the phrase. And truthfully, some statistics indicate that only 2% of applications ever finally end up as registered trademarks. Going back to the examination for the critical race theory, intellectual property, the biggest concern that had never occurred to me before I read the paper was not in the fact that none to date, none of the exact Black Lives Matter applications, that exact phrase, have registered. There's only one sort of the longer phrase that has registered, and it's Black lives will matter to them when Black lives matter to us, with a play on to be 200. Yet that was filed by a community activist in New York, but I cannot see that trademark is being used for anything whatsoever. But the concern of the scholars, the critical race theory scholars, was in the other lives matter. The Irish lives matter, the fat lives matter, Christian lives matter. And they proposed, that there should be a collective mark to give protection to collective phrases, or perhaps a provisional hashtag mark, and they also suggested that the Trademark Office review all of its procedures in granting or refusing applications to eliminate any cultural appropriation. Their thought was the Irish Lives Matter was just basic cultural appropriation that was colorblind by the Trademark Office. Irish Lives Matter is a registered trademark, but there has been a big outcry by many in the Irish American community that it's very insensitive, and people have been asked, as one tweet said, don't buy your t-shirts, don't buy your Irish Lives Matter t-shirts at Walmart because it's just two wrongs at the same time. What I think many of the suggestions to require more secondary meaning for phrases until they really do establish source indication are well taken. And in terms of, the other Lives Matter registrations, applications, attempts to benefit from the social capital built up by Black Lives Matter, to enjoy that halo effect, because, everyone, Black Lives Matter is everywhere. So why not, jumpstart on that with your other Lives Matter? My thought is something more akin to dilution, that famous trademarks are protected from blurring and tarnishment. They're even protected from bad parody, which usually is grounds for fair use of trademarks. I've seen cases that ruled that, the parody went too far, it was in poor taste, and they ruled in favor of Budweiser. So that would be my proposal. But in general, I think trademark is serving its purpose at preserving these iconic phrases that actually are a rallying cry. If anything demonstrates that slogans are still a rallying cry, it is the phrase Black Lives Matter.